In the previous episode, we talked about Garnishee proceedings and charging orders. Today, we will discuss oral examinations and prohibition orders in the context of enforcement of judgments. Yes, firstly, there are a number of public searches that can be conducted, including, for example, land searches at the land registry and company searches at the company's registry. A judgment creditor may also engage a private investigator, but in many cases, there may be little or no information available. One useful method of enforcement is to apply for the oral examination of the judgment debtor on oath, or a director of the judgment debtor if it is a company. This requires the judgment debtor or director, as the case may be, to attend court in order to be examined about their assets and financial position. The rules are slightly different depending on whether the judgment debtor is an individual or a company. In broad terms, the scope of examination is wider for individual debtors, and the sanctions that may be imposed are more severe. Where the court makes such order, at the first hearing the court will make standard directions requiring the judgment debtor to disclose all documents regarding his assets and financial position, including bank account passbooks and statements for a specified number of years, accounts for a specified number of years for a corporate judgment debtor or for any business of which an individual is sole proprietor or partner, all tax returns and assessments for a specified number of years, all share certificates held, all deeds or land registry entries for properties owned by the judgment debtor, whether legally or beneficially, registration details of all vehicles owned, all wage or salary slips. The order requiring the judgment debtor to attend court for oral examination should have what is called a penal notice on it, essentially warning him that he must attend the examination whenever required, and that if he fails to attend without good reason, he will be liable to face contempt of court proceedings for an officer of a corporate debtor, or liable to arrest for an individual debtor. Further, in the case of an individual judgment debtor, following examination, the court may order his imprisonment if satisfied that the judgment debtor was able to satisfy the judgment debt wholly or partly, has disposed of assets with a view to avoiding enforcement, or has willfully refused to make full disclosure or answer questions under oath. In my experience, oral examination can be a powerful tool for enforcing a judgment. It forces individual or corporate debtors to disclose assets available to satisfy the judgment debt, with the possible sanction of imprisonment for individuals, while in many cases corporate debtors in particular will be willing to settle or pay the outstanding judgment debt rather than disclose sensitive financial information. Yes, in appropriate cases, a judgment creditor may apply for what is called a prohibition order, stopping an individual judgment debtor from leaving Hong Kong. In appropriate cases, a prohibition order may even be made in intended actions or pre-judgment, although they are easier to obtain after judgment. Often, in fact, prohibition orders are used in conjunction with applications for oral examination. In other words, to stop the judgment debtor from leaving Hong Kong before the examination can take place in order to secure his attendance, but can also be sought in other cases. The application is made ex parte, that is, without notice to the debtor, to avoid tipping them off and leaving Hong Kong before the order is made. The application must be supported by an affidavit which sets out the reasons for believing that the judgment debtor is about to leave Hong Kong, as a result of which satisfaction of the judgment debt is likely to be obstructed or delayed. The prohibition order, if made, must be served on the Director of Immigration, the Commissioner of Police, and the court bailiff. It should also be served on the judgment debtor if he can be found. Where possible, the Immigration Department should also be provided with the judgment debtor's date of birth, Hong Kong ID number, passport number, and any known aliases. If a judgment debtor who has been served with a copy of the order tries to leave Hong Kong, he may be arrested by any immigration officer or police officer. If a judgment debtor attempts to leave Hong Kong before he has been served with a copy of the order, He cannot be arrested, but will be prevented from leaving Hong Kong. A prohibition order can be a useful tool in appropriate cases to ensure compliance with an order for the judgment debtor's oral examination where there is reason to believe that the judgment debtor may otherwise leave Hong Kong in order to avoid the oral examination. This concludes the second part of our video on enforcement of judgments. Ensuring justice and reinforcing trust, Hong Kong continues to stand as a beacon of legal excellence.